Hello and hi, my beautiful students. I hope you are doing all good. I think you're in the best of your time. So, here we'll start with a new and an interesting topic on private international law. And today we'll be doing with the fundamental and concepts and issues of the private international law. So, till now, whatever lectures I have delivered, I hope you have understood the importance of the private international law, how it began, the difference between the private and the public international law, the characterizations. Now, I'll start with the issue today, depending upon where the private international law just began and what was the issue for bringing private international law as an important law subject in your BBLLB course. So today we'll look forward and read about the fundamental concepts and issues of private international law. So here, if we go back to the history and we'll flip to the past, so we'll get over to the one of the most important cases, also termed as a notorious case of Ogden versus Ogden. Now, this is the case where the first ever private international law conflict began. And there were two parties, one from French and the other from England. So the Frenchman was married to an English woman. So the French having a domicile in France and the English woman having a domicile in England. So though they both married in England, but after some time of marriage, some years of marriage, so the marriage was brought down due to some issues. There were breakovers, and the Frenchman decided to get an annulment of his marriage in the French court. Now, interestingly, the French court has delivered a judgment and said that no marriage of minor valid without the parental consent. So, at the time of the marriage, the Frenchman was 19 years of age. And according to the French law, 19 years was a minority age. 21 years is the majority age in France. And what the French court said, that if somebody had to marry in French below the age of majority, then they should have a parental consent for that marriage. And since the Frenchman didn't have any parental support, so the marriage was void ab initio. And for this reason, the Frenchman didn't have to take any divorce regarding the marriage. And when the problem was all said, but the problem began when a woman married an Englishman in England. And when the Englandman came to knew about the marriage, the previous marriage, he told her wife to get the annulment of her marriage. And after that, only the Englishman would marry her. Now, the question was that the wife said the marriage was already annulled by the French court. But the English court didn't want to get into it. It said that in the eyes of English law, it was a valid marriage, since the majority age in England is 18 years. And since both the parties was above the majority age, so it was a valid marriage. So the two connecting factors in this case was the purport husband was domiciled in France and the marriage was solemnized in England. And since this marriage was solemnized in England, the English court told that they would follow the English law, which is known as the lex fori, the law of the land. So for this reason, it is also known as the notorious case, which is infamously known as the Ogden versus Ogden. So here is the issue where the first issue of the private international law came into existence. So the effect. The Court of Appeal held that the French rule was only formal and not essential. Therefore, first marriage was valid in the eyes of English court. Now, annulment of second marriage was allowed. So, the Englishman was the second marriage that was done between the Englishman and the Englishwoman was annulled, since the first marriage was valid in the eyes of the English law. So, what was the outcome? She was married to neither, plus considered to be married to Frenchmen in England and Englishmen in France. So, this was the case. Now we come to the issues of the characterization. So, what is the goal? Reveal the relevant rule of choice of law. This is usually clear, but there is an occasion in which difficulties do arise, where English law and relevant foreign law do not agree, where the concept is unknown to the law. So, in this case, the law of both the lands was justified in their place, but when it comes into different countries, they were different at the point of the juncture. So, what is the basis of characterization? So, after this dispute, so they all decided to have an application of the law, and which said that where the application of the local law takes place, the justification is if usurpation of foreign law is allowed, no application of local law. It says the lex foris problem may result in adverse outcome like Ogden versus Ogden, may be an issue where local law does not know. This happened in Dean Close versus Culliner. Now, what is lex causa, where application of the appropriate foreign law takes place? So, this is very important. Now, what happened? The case law between the Re Maldonado, a woman domiciled in Spain, died in a state. She left movable property in England. This was claimed by both Spain and England. So, in this case, there was a woman who was domiciled in Spain and has died in a state living immovable property in England. Now, both the government, the English and the Spanish government, they claimed the in-estate property of the woman. Why? What does the Spanish rule applies? Property was never ownerless and state was the final heir. Since the Spanish law tells the place where the immovable property is the property of the government if someone dies heirless. Now in England, the law is different, it's just opposite. It states if someone dies leaving property in England without any heir, then the property goes to the English government. So, if we look into the case, which is the applicable law, the Spanish or the English, depending on the lex foris, question on succession of the movable property, Spanish rule would apply, or the question on bona vacanta, ownerless property, the rule that is title to property governed by lex situs, therefore English law will apply. Now the incidental question, one that arises with a major question in a case. Illustration. Greek national domiciled in Greece dies in Greece leaving movable property in England. Moreover, according to Greek law, his widow is entitled to portion of the estate. Now in this case, caveat was taken. The marriage has taken place in England, valid in England but not in Greece. Why Greece law requires marriage before a Greek peace? This was important because every marriage in Greece used to be taken in front of a Greek priest, and since the marriage was not taken in front of a Greek priest, so the marriage was void. So there were two views. So view number one, it says widow should not get, why? Full effect to English law conflict rule that in relation to succession Greek law should apply. Now view two, widow should get it, why? Full effect to English law conflict rule that validity of marriage should be that of English law should apply. Now, during such instances, what the court do, they invoke the renvoi. Now, what is renvoi? It arises whenever a rule of conflict of law refers to the law of another country. So in the latter instance, it may refer back to the first case. Does this refer to only the local law of the country, or it laws on the conflict of the laws as well? Now, what are the approaches taken by the court? Now, the first approach that the court can take is that It applies the domestic rule of the country in manner applicable to its citizens without regard for any other fact. This method requires proof of the domestic law of the country but not its choice of law rules. Now, what other renvoi can be applied? Now, there is a partial or a single renvoi theory known as the accepting the renvoi. The local court accepts the reference back from the foreign law and apply the domestic law. So, if it does not find a solution in the first instance, then they apply the partial or the single renvoi. Now, if they do not find any solution in the second point, then they move to the third, that is the total or the double renvoi. The court would decide the same way the foreign court would, including the law and its own conflict of law rules. So this is how a case is decided in every international court or a local court when a foreign element is included in it. I hope this class was an interesting one. We'll look forward to know more about renvoi in the next class. Till then, thank you very much. Have a good day.